guys, Igama AsandaNtini, and welcome to today's video and welcome to my channel if it is your first time joining in, and if you're a candidate attorney, welcome and all the best with everything that you are doing, and welcome to today's video. Today we are going to be speaking all things your first consultation alone as a CA. That's it. Okay, those of you that don't know, I finished my articles in February this year and have recently passed my boards, finally passed all my boards. And so I do have a video where I'm sharing all of that. And I do have other videos on my experience as a candidate attorney throughout the years. Anyways, throughout the past 2 years, because I did my articles for 2 years instead of one. Anyways, with that said, let us speak about your first consultation. What do you do? What do you prepare? First thing that you need to prepare, okay, sometimes you get urgent matters like going to consult for a bail application. That's a different story. But if you're going to be consulting for the first, something on my throat. If you're going to be consulting for the first time, for a matter that's not as urgent, like a divorce matter, first thing that you need to do is to be prepared. What are you prepared about? You're going to prepare yourself on the law. What does the law say about different types of marriages? Be prepared to answer any question that a client, in terms of the law, could ask. The client could ask you questions on customary marriage, so be prepared for that. Because most of the time when a client makes an appointment, they just say, I want assistance with a divorce, maybe share that they have minors so that the person who's taking down the appointment would tell them what to bring. If they have minor children, they'd be told to bring what are these things? Documents, that birth certificates, all of those things would be asked to say, okay, bring same when you are coming into your consultation. So be prepared to be prepared in terms of the law. You're going to be, if you're going to be consulting for a retrenchment matter, be prepared about all of the sections in the LRA, because client would ask you, what does section 189 say? They won't say what does section 189 say, but it's very nice. Clients really feel good if you're going to be saying, no, in retrenchment is in terms of section, what in terms of section, okay, so yes, be prepared. That's point number one. So be prepared, know your sections. Speaking of divorce, going to be quoting the Divorce Act, you're going to be quoting the and explaining to it. That's, yes, you're going to be flexing, because clients like that. Clients actually like feeling like, okay, I just went to Umeli and they started quoting those sections. You're going to quote those sections, but then you're going to explain them in layman's terms. So that's why you need to be prepared. Because as you understand, if you're going to be going for a bail application, section 60 of the Criminal Procedure Act, tell them about it, but explain it in layman's man while you are taking notes for your affidavit if you're going to be doing a Schedule 5 or 6 bail. So explain to them, con Schedule 5, con Schedule 6, what's the differences? What are the differences? So be prepared. Yeah. Golden rule, always be prepared. Number 2, be confident. Don't be cocky, don't be arrogant, because many attorneys, candidate attorneys and junior attorneys do not understand. I'm not going to say they do not understand, but they're just too cocky and too arrogant that, oh, the moon is very nice, that they don't know the difference. They come out as cocky and you're like, dude, calm down. We here, like, we are all people, so calm down. Yes, be confident. You have to be confident in, as I was saying, with to quote sections, quote this and that, explain in layman's terms. Don't be too lawyery with a client. So that's what you do. And number 3, don't be too long. You are on billable hours. We work for our time. We get paid for time. Yes, you are saying you don't really get paid, but the firm itself charges for its time. Charges for its time. So understand, always be in mind, we are on billable hours. Everything that the longer you take in a consultation, consulted for 3 hours with a client that you could have consulted in an hour, they only pay for 1 hour. That's not on. If you're going to be consulting, the longest consultation you should do should be 1 hour. Unless you are filling in forms, you are calling third parties on the day, that's a different story. But a consultation should be 30 minutes max. In your 30 minutes, if you are prepared, your consultation could be 30 minutes because you have all the answers, you have all the information that the client might need. So yes, the longest you can do is 1 hour. Anything longer than that, you're pushing it, and you might actually have issues with you are taking too long in your consults. So ask all of the important questions. So if you are prepared, you know which questions to ask. If you are doing a bail, you know, okay, do you have a passport? Where is it? Do you have an alternative address? All of those things. You already have your questions in mind. Even write them down. I used to write things down. Even when I started with my new job, where most of our consultations are telephonic, when I first started, I used to write down, okay, this is what I asked clients, this is what I asked clients as per compliance of the company. In the same sense, when you are going for a divorce, write down points. I need to ask, when are you married? What community? Where for jurisdiction? Where is husband? Where is wife? So ask those questions. Also look at the directives of each court, because I know that in the Purchasing Code they now want a proof of residence. So ask all of those things. Do you have this? Do you have this? Do you have this? So be prepared in that sense. Write them down if you must. Imbuzo yako. If you are doing a labor matter, be mindful of prescription. In any matter, be mindful of prescription. Divorce doesn't really prescribe unless obviously you want to figure with summons who say safe and they want to now send a notice of intention to defend, or they don't want to defend, they just want to say do a plea or whatever, come into a plea agreement. So be ready for all of those things and be ready to ask all of those questions. So yeah, don't be too long. Finally, don't be over promising. Don't sell people a dream, because what you say as clients, what you say, believe you, they understand that what you say will be used against you in court. They will use what you say against you, principal. And if you don't have a good relationship with your principal and you don't write things down while consulting, I forgot to write this down actually. While consulting, write everything. So everything, like client came in, client said this, I said that, because you need consultation notes obviously in a file. So write everything down. What happened? This is what happened. This is what I said to client. Their matter is prescribed in Ukana system. What was their response? Important things like that, you need to write them down, because at some point they might backfire. I advise client that they have not defended their matter in 2 months. Could be that judgment has been granted. Write all of those things down. Good, see, you've said them, and advise them. We're going to apply for condemnation. Advise client that condemnation might be granted. It could not be granted. So write all of those things down and write a reaction. And if a matter is out of date, have an affidavit prepared. Like, have a precedent. When you start working as a CF, a precedent for things that you're going to sign, to make clients sign that might backfire, like prescription things, condemnation things, and late filing or whatever. Have something that you put in the file. I advise to client, your matter is late, but then we're going to proceed with it. And it could be that our response or whatever could be struck off the road, could be could be dismissed, any application that you do. So write that down, make them sign with it. If something has no prospect but they want to proceed, they are adamant that make them sign those things. Golden rule in practice, even when consulting, not just in practice anyway, cover your ass. Like, cover your back. So the way to cover that is make people sign stuff, make people have things in writing. After a consultation, if you forgot to write things down, send them an email confirming AsandaNtini. If you were on the phone, send them an email confirming okay, this is what we spoke about and this is what you said, this is what I said. I confirm so that you have that in file should anything ever go wrong. You get, we don't want things to go wrong. Things shouldn't go wrong, but they might. And if they do, and clients lie. I'm sorry to say this, but they lie. And what else? Give a clear estimate of a turnaround time. Do not say I'm going to have your letter ready, not letter. Letter could be ready in an hour or after the consultation or within the consultation. But don't say your summons will be ready in the morning when you know very well that you have so many other files that are urgent that you are dealing with and their matter is not really urgent, and you give them a turnaround time that's just not possible. You give them you consulting for a divorce matter, you know that they are minor children, and you tell them that a divorce could be finalized in a month's time. Family advocate takes their time. Do you know how long they will take? And if there's no settlement agreement and the court says no, in as much as the court is the upper guardian, we just want to have a report from the family advocate and the settlement agreement be endorsed by the family advocate. So advise them, these things take time. So don't overpromise, and also have a clear turnaround time to ILO. So you should know how does the court work in a certain area. How does the court work? How do we set down matters? You need to give people a certain amount of time before a matter is set down. Sometimes it's 14 days, sometimes it's 13 days to make an application. 30, not 13, 30 days. So advise them of the turnaround time. So if you're going to make an application, this application needs the other party to respond to us. Needs to be notified and given this amount of time. So make that very clear to them. Okay, everything has been done. They've shared their story. No, I don't like my husband. My husband has been doing. Maybe they don't even want a divorce. They just want to vent. Confirm instructions. Maybe they just want you to do a mediation before, or they want you to do a mediation before the divorce proceedings are done. Maybe it's a client that wants to do a certain application, an application to compel or whatever it is, instead of this thing that you've assumed at the face of the facts. So you have to confirm instructions when you've done all of the consultation, because you could be assuming, no, for send the action, but that's not what they want. And they come back to you and say, that's not what I said must happen. Maybe you decide you're going to contact your employer, and the client was just telling you, I have this problem that I foresee happening at work. And what does the law say? You tell them, and then they say, okay, please pen my file. Or I just wanted to know that, pen my file. I just want to see if employer does proceed with this. And when you jump and call the employer, then put them in jeopardy at work, to also contact Abamel instead of coming to us lodging a formal grievance with the firm or the company that is before you go externally. So confirm instructions, so that you don't, one, do an application, waste this you go to court, waste this and client says, nope, that's not what I said. Imagine coming to court, no, I've never said I want to do this application. So confirm instructions. Also, confirm instructions, because you're going to have to report to your principal. It's okay, I consulted with this client, these are the facts, because facts, yeah, okay, but what's the issue? What are we doing? What did the client say we must do? What did the client say we must do? Okay, what are the procedures that we're going to follow? So be clear and remember all of these that I've shared. They're all over the place, but you get what I'm saying. Anyways, good luck with the rest of your articles, and good luck with your journey that we are in of becoming a lawyer in the Republic of South Africa. Anyways, I hope you guys enjoyed this video, and please do subscribe, share this video, comment, and all the best. Bye guys.